Welcome to a brief roll call training for warrantless arrests under 15A 401B. When can we make an arrest when we do not have a warrant? So Part 1 of this statute allows us to make arrests for any offenses that occur in our presence within our territorial jurisdiction. So it has to be a misdemeanor or a felony that occur in our presence. But what does presence mean? Presence is witnessing a crime through at least one of the senses, whether it be sight, hearing, smell, touch, or taste. But please do not taste crimes. So an example for Part 1 of this statute. You're conducting a foot patrol in downtown Hillsborough. As you walk past the wooden nickel, you hear a loud smack. A woman screams and yells, "Why did you hit me?" You did not see the alleged assault. What can you do? So the answer is, you can issue a citation or make the arrest. As with any other criminal encounter, please investigate this incident further and interview involved parties and check for any witnesses. So how exactly are we able to make this arrest when we didn't see the alleged assault? Well, think back to our definition of what presence means according to the courts. It's any of the senses. We heard the slap, we heard the immediate follow-up statement, "Why did you hit me?" Therefore, the offense occurred in your presence, and you can make a warrantless arrest. So Part 2 of this general statute tells us when we can make warrantless arrests for offenses that occur outside of our presence. So when none of the five senses are triggered and we didn't witness any part of the offense. Well, if we develop probable cause that the offense occurred and probable cause that the offender probably did it, we can arrest for any felony without a warrant. But with misdemeanors, there's only a few situations where we can make that warrantless arrest when the offense occurred outside of our presence. Those are when the suspect will not be apprehended unless immediately arrested, or they may cause physical injury or damage to property if the arrest doesn't immediately happen. And there are specific crimes that are outlined in the statute where we can make these warrantless arrests for misdemeanors. Those specific crimes where we can make these warrantless arrests for these misdemeanor offenses are specifically defined in the general statute. They are concealment of merchandise. That does not count shoplifting. That does not count larceny. Concealment of merchandise, 15-72.1. Impaired driving offenses. You can arrest someone for DWI when you did not witness them driving, based on the totality of the circumstances and other evidence that you may obtain during your investigation. Domestic criminal trespass. Domestic violence assaults. That's assault, affray, assault with a deadly weapon, assault by pointing a gun. Does not include communicating threats. All right, and DVPO violations. Obviously, it's one of those shall arrest offenses. Let's test your skills with another example. You respond to Home Depot for a larceny that just occurred. Loss prevention observed a male suspect take a DeWalt drill from the shelf and carry it past the last point of sale. You arrive on scene and the suspect is in the parking lot, sitting in his vehicle. What can you do? Based on the information we have in our question, you can stop and detain the suspect. You can identify the suspect. You can search him in the vehicle for the stolen item and return it to Home Depot. Remember, we can search for any place that DeWalt drill could be found. You can issue a citation. You can obtain a warrant for arrest or criminal summons, but you cannot make a warrantless arrest in this case in terms of actually taking physical custody and transporting him to jail. It does not meet one of the elements of 15A 401B. Here's a little more explanation as to why we cannot make that warrantless arrest. The suspect did not conceal the merchandise. He simply picked it up from the shelf and walked out the door with it. It's a larceny, and larceny is not listed in 15A 401B2. There are also no other qualifying offenses that have been given in this scenario. But just because you can't arrest doesn't mean you can't cite. A citation would be allowed in this case. All right, using our last example, the larceny at Home Depot, let's explore your knowledge with constitutional law and best practices. Once a suspect is detained, can you move him to the loss prevention office for further investigation at Home Depot? How does Miranda apply to any questioning? If you know who he is and he flees the scene, how should you respond? Our first discussion question: once the suspect is detained, can you move him to the loss prevention office for further investigation? If officers move someone after being lawfully detained without consent, it may be considered an arrest and should be supported by probable cause. However, you may move a detainee short distances for safety, security, or other legitimate purposes without it being deemed an arrest. Handcuffs are also permissible if they are a flight or security risk. So you make this encounter, you make this stop of our suspect in the Home Depot parking lot. You're by yourself, backup is not coming, or they're tied up on something, or it's just gonna be an extended period of time. But you have to investigate this case further. You have a couple options. You can get the person's information, confirm who they are, and release them for the scene pending charges in the future. Or you can detain them, bring them back into the loss prevention office at Home Depot. They're still in the parking lot, that is a short distance, to continue your investigation. They would not be free to leave, and it would not be an arrest. That does not mean that you can transport them to the police department for further investigation. That would need to be supported by probable cause and would be deemed an arrest. How does Miranda apply to any questioning with our suspect at Home Depot, whether it be in the parking lot or in loss prevention? Well, as long as the suspect is detained and not under arrest, Miranda does not apply. Here are some tips to keep from triggering Miranda in these type of encounters. Tell the suspect they are not under arrest. Only handcuff if necessary, if they're a security or a flight risk. Keep them out of the backseat of your car. Refrain from moving them unless you have to. Don't create a situation where a reasonable person would feel they're under arrest. We get dispatched to our Home Depot larceny, and we are informed of who the suspect is. Loss prevention officers recognize him as a repeat offender, and you recognize the name. There's no question who this person is. You arrive on scene, and you see them fleeing from the scene in their vehicle. You attempt to conduct a traffic stop, and they don't stop. How should you respond? Remember risk versus reward. If we know who they are, and they're not a risk to themselves or others, let them go. Continue your investigation at Home Depot, and we'll get warrants later. Even if we don't know who they are, get a picture of them, a vehicle description, tag number, etc., and we'll continue our investigation. Last Home Depot scenario. Same call. Suspect steals a drill from the shelves, does not conceal it, walks past the last point of sale and is in the parking lot. He stole the drill. Loss prevention has a video of the offense. There are 2 credible witnesses willing to testify. When you arrive on scene, the suspect is still holding on to the drill in its original package in the parking lot. You stop out with him, you start asking him some questions. The suspect refuses to identify themselves and denies any wrongdoing. What can you do?
Lock his ass up! Lock his ass up! You're going to jail! You're going to jail!
We can make an arrest in this case. Even though it's still a larceny, and it happened outside of your presence, some other things triggered our ability to make this warrantless arrest under 15A 401B. Because we can identify who they are, the offender will not be apprehended unless immediately arrested. The offender also committed another offense in your presence: resist, delay, and obstruction, RDO. To add more explanation and considerations we need to have in this case as to why we can make a warrantless arrest, remember our suspect is lawfully stopped. We have video and witness evidence to support that he did steal the drill and is in possession of it when you encounter him outside of the store. Even though North Carolina is not a stop and ID state, which means we can't force people to identify themselves with every encounter, but we can if they're operating a motor vehicle on a public street or highway, and we can request identification when they are suspected of a crime. You at least have reasonable suspicion that an offense occurred and they are likely the offender. In this case, we have probable cause to stop and charge this suspect. But because he won't identify himself, he is delaying your investigation. If you had his name, you could do the less intrusive means to resolve this by issuing a citation, but he's not allowing you to do that. In totality, he is resisting, delay, and obstructing your investigation, which is a completely separate misdemeanor offense that is happening in your presence. For our third and final example, You respond to an active disturbance at a residence. A husband and wife have been arguing all night. Prior to your arrival, the wife threatened to shoot her husband and has been breaking his personal belongings. The wife has access to a handgun, had been waving it around, and the husband fears she will use it. The wife admitted that she threatened her husband and said she doesn't care what happens. What can you do? The answer is, we can make an arrest. We can seek a warrant. We can even refer the victim to a magistrate, even though that's probably not the best idea. Based on our policies and due to the dangers associated with domestic violence, in this specific scenario, making the arrest and seizing the firearm is the best option. Explanation. Threats were communicated and property was damaged outside of your presence. None of these offenses are listed in 15A401B2. No assault occurred. North Carolina law does not require officers to make arrests in DV situations, except for DVPO violations. However, unless immediately arrested, she poses a threat to him and his property, which satisfies 15A401B